So good afternoon and hello. It's good to see everyone. Welcome to the Alternative Dispute Resolution Certification Working Group. And you just heard that this meeting is being recorded. Angela, would you please take the roll?
Sure. Armstrong,
Here.
Coulter, Curtis,
Here.
Dinkin,
Yes.
Dubo, Ellis,
Here.
Dr. Getz. Dr. Getz.
We didn't hear you. Do you mind?
Here.
Yes, thank you. Higuchi,
Here.
Hodgson, Jones,
Here.
Kelly,
Here.
Opakin,
Here.
Cruz,
Here.
Lowe,
Here.
Judge Lucky, Pulaski, Judge Pichon,
Here.
Robertson,
Here.
Tuckman,
Here.
Welch,
Here.
and Yemshaw.
Here.
Thank you.
Thank you, Angela. So next on the agenda is the call for public comment. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Angela, would you please provide the instructions?
Yes, for those who are participating by Zoom, please use the raise hand function at this time to indicate that you would like to make a public comment. For those who are participating by phone, you can raise your hand by dialing star and number 9. We will allow 3 minutes for each speaker. The on-screen timer will begin as soon as you start your comment, and you'll be verbally alerted once you have 30 seconds remaining. So if there's anybody who'd like to make a public comment at this time, please use the raise hand function.
And Angela, are there any members of the public who wish to speak?
I don't see any raised hands at this time.
Thank you. Next, we'll move on to the approval of the minutes. Those are the minutes from the open session on February 12, 2025. Are there any corrections or modifications to the open session minutes? Okay, I don't see any hands. Therefore, we'll move on to staff has an update regarding the minutes from the last meeting. Erica, would you like to take that?
Yes, thank you, Chair. So briefly, I'll just note it was brought to our attention that a couple individuals were marked as absent during the limited votes that we did have at the meeting last a month or so ago. So just a brief reminder for those of you who are attending, we are going to be quite deliberate in making sure that we can hear you during your vote. So as you heard with Dr. Getz a few minutes ago, if we can't hear you, we will ask again to make sure that we capture your vote. But especially for those who, please do come off mute as soon as feasible so that we can hear you when it's your turn to be called upon. And then particularly for those who may have to go off camera for whatever reason during the meeting, we especially ask that you come off mute because we can't even see if you are indicating your interest in voting on the particular item. And if you're unable to be heard on the item, you are marked as absent pursuant to the State Bar procedures on voting. So I can answer any questions you may have on that, but I think we're in good shape going forward. So thank you.
Thank you, Erica. May I have a motion and a second to approve the minutes?
Motion to approve the minutes. Second.
Thank you. And Angela, would you please, oh, I'm sorry, that was motion second. Any discussion at all? Angela, would you please call the roll?
Yes, Armstrong,
Yes.
Coulter,
Yes.
Curtis,
Yes.
Dinkin,
Yes.
Dubo. Paul, are you here? Dubo, no. Ellis,
Yes.
Dr. Getz. That's a yes. Higuchi,
Yes.
Hodgson. Sarah Hodgson, Jones,
Yes.
Kelly,
No.
Kopaken,
Yes.
Cruz,
Abstain.
Lowe,
Yes.
Palevsky,
Yes.
Robertson,
Yes.
Tuckman,
Yes.
Welch,
Yes.
Yamshon,
Yes.
and Judge Pichon.
Yes,
So the motion carries with the majority voting in favor.
thank you, Angela. Next on the agenda is my chair's report. However, I do not have anything to report at this time. And we'll move on to the staff report. And I've been informed that the staff does not have anything to report at this time. So now we'll go to the business of the working group. And that is item 2.1 for 30 minutes. It's a discussion regarding areas of focus for the working consideration. And that is presented by Alan Weiner. Thank you, Alan.
Thank you, Judge Pichon, and good afternoon, everyone. We're going to resume something that we started at the first meeting, which is going through the topics list, which I'll put on screen in just a minute. Just a couple reminders about that. First, the scope and purpose is really to capture topics, at this time is to capture topics that should be considered by the subgroups and by the full working group, not to have a discussion about those topics. So we're really just trying to build a list of topics or issues that will be addressed down the road. It's also an evolving document, so you're always welcome, excuse me, to add topics that you think should be included. You can send staff an email about that, or you can raise it at one of the full working group or subgroup meetings. That said, today we're not going to go back and revisit the topics that were discussed at our last meeting. We're going to pick up where we left off. And so that is going to, I'm going to share that, I hope. Are you able to see my screen?
Yes.
Great, thank you. So we're beginning with certification of practitioners, and just maybe I'll just do a quick preview of the main topics that we have that we're going to cover today. Certification of practitioners generally, certification of firms or organizations generally, tiers or levels of certification, grievance processes, certification fees, and out-of-state firms or practitioners. I'm going to hopefully capture any comments that you have on these topics. I'm sorry, I shouldn't really say comments, but we're looking for additional topics. So any topics that you want to add to these lists of things that we should address. And I will try and capture those in track changes, and it will probably be pretty messy at this point, but I will clean it up and it will be redistributed, showing the changes. So hopefully folks have had a chance to review this list at least once. I'll go through the general categories pretty slowly and ask for any additions. And I see Mr. Kelly's hand. Ron?
Thank you. This topic, I hope, goes in there because it's raised by the public comment that we got, and it's really a threshold question. And I'll just read the one sentence question from Philip Diamond's letter, which was, if the statute doesn't direct the state bar to develop a certification system that involves qualifications, why should the state bar do so? Especially since, as I understand it, the LA scandal that started all of this was wholly related to ethical issues and had nothing to do with the provider's qualifications. Phrase that however you want, but it seems to me to be a very threshold question. Should we be developing certifications that go beyond what the legislature has charged us with? Thank you.
Thank you. not certain that this is the best place for it, but it's where we're starting out, so I'll put it here and it may apply a number of places. Any other additional topics that members think should be discussed under the general heading certification of practitioners? Yes, Ms. Cruz?
Perhaps just right above Ron's new comment under between 3 and 4, just what exactly is the practitioner certifying? And then I think Ron's comment then follows it, right, in terms of not potentially doing qualification-based requirements. Or
Sure,
have-
just a question about what the practitioner is certifying. Are you specific in your use of practitioner, or is it practitioner and or state bar?
I think I'm just trying to follow the topic in general certification of practitioners. So what exactly is the practitioner agreeing to do to be certified, maybe, if that goes to your point, Alan?
Thank you. See Mr. Kelly's hand again? Or maybe still?
I'm sorry, I just didn't lower it.
Thanks. Mr. Dinkin? I believe you're muted.
Under the certification of practitioners and perhaps also as it relates to firms, under number 2, where you discuss different types of conflicts, you have like commercial, family, real estate, construction, then community. And I wonder if community should be drawn out as a potentially a separate type of practitioner. I just think community mediation perhaps maybe should be examined in a different light than different types of business type conflicts, because it really is its own grouping of providers and organizations.
Right. Ms. Curtis?
Yes, and this is to follow on with Steve's point, to add restorative justice practitioners.
Thank you. And Ms. Kopeckin?
My comment was similar to what Dana Curtis's comment, following on Steve's. I think also ombudsperson, or maybe sort of a more broadly, not restricted to, mediators, or I think ombudsperson probably covers it. Thank you.
Thank you. Mr. Yamcha?
Thank you. I think there should be an exception for areas of practice that the legislature has already created. I sent Angela the business and profession code sections for the next arbitrators subgroup because there's an entire arbitration system with rules for providers, neutral training for automobile warranty arbitration. So I think that could create a potential conflict between what this group is doing and what already exists by dint of the legislature.
Thank you. Any other suggested addition of topics under certification of practitioners in general, Mr. Kelly?
If we're going to be talking about places where the legislature's already laid out regulatory and oversight authority. I know I've heard from community programs who say, we do court programs all the time and we already have the same procedures as this legislation calls for. We're already overseen by the local superior court. So I don't know if you want to try and capture that in some way.
Court program mediators, will that refresh our minds? Thank you. Mr. Tinkin.
To the same end with regard to legislation regarding community mediation, I would add the Dispute Resolution Protection Act. So there are many community mediation entities that believe that the legislation, the Dispute Resolution Protection Act, DERPA, covers their qualifications and so forth.
Thank you. Mr. Tuckman.
This may be a observation or question, but the subpoints under 2, I do agree that we need to think about those different types of conflicts. But I'm wondering also whether we're talking about if some of them should belong under discussion topic 1. Ombudsperson, for example, that seems like an ADR processes as opposed to a type of conflict. So I don't know if we want to worry about categorizing them now, but they are broken out separately. And there are likely others that we would want to think about.
Thank you. Ms. Curtis.
Yes, this may belong, maybe implicit in number 2, but it's, are volunteer mediators, are we wanting to provide a process for volunteer mediators to be certified, or is it for people that are making money at it? Professional mediators in that sense.
I'm going to put that down as a new topic, or as a new item number. Thank you. Other suggestions? At this time, again, it's evolving, so you can always submit other ones down the road. I am not seeing any, excuse me, any more hands. So I'm going to move down to the next general topic area, which has to do with certification of firms. And what topics might be added to this list of discussion topics that we already have regarding certification of firms. Ms. Hodgson?
I have 2. I think clarifying the definition of what firms means in this context, and relatedly, if we have a firm that is perhaps providing different types of alternative dispute resolution, for instance, some practitioners are providing arbitration, others ombudspersons, others mediators. What does the certification look like for the firm as a whole?
So just to clarify, you're saying if a firm provides both mediation and arbitration, what does that look like in terms of certification of the firm?
Exactly.
Thank you. Mr. Pilevsky.
There's a bunch of requirements imposed on providers, like posting quarterly consumer reports, fee waivers, not administering cases with prevailing party attorneys' fees. So they should certainly have to certify not only compliance, but systems in place to ensure that that's followed.
Mr. DeVoe.
Actually, I was about to turn it off, Alan, because that last question covered my thing.
Thanks. Ms. Becken.
Yeah, I guess the relationship to courts and perhaps governmental entities, does this apply? Does it not apply?
You, Mr. Kelly.
When Ms. Robertson, Professor Robertson perhaps, interviewed Senator Umberg, I was really struck with his apparent insistence that organizations that provide lunch for people at a gathering somehow disclose that if one of their panel members was mediating or arbitrating a case. And that just seemed like a very difficult thing to keep track of, all the attendees and how they interact with potential attorneys that might be attending. Something that makes reasonable standards for disclosure of organizations. I'd like to see a topic.
That host events, I'm just going to say. And so relationships between a firm that hosts an event and parties or lawyers or parties who may be in the room, maybe at the event.
And I'll just notice that lots of bar associations, for instance, have sponsors where somebody's paying for the drinks, somebody's paying for the hors d'oeuvres, and trying to keep track of all of those kinds of things would be a real burden, it seems to me, for provider organizations.
At events such as a conference or something like that. Is that what you're thinking about there?
I'm not sure what Senator Umberg, I'm sorry, I'm not sure what Senator Umberg is thinking about. But I just wanted to raise the point of reasonability.
Thanks. We're getting feedback from someone's phone. I'm not sure who. It stopped right now, so I hope it's not mine. Mr. Dinkin.
Yes, same line of reasoning that I had mentioned with community mediators, it would go the same with firms. So community mediation organizations and or DERPA community mediation organizations, are they going to be perhaps carving out an exception versus a fee-for-service provider, and how do we handle those types of entities versus the fee-for-service entities?
Thank you. And I still see your hand. Anyone else at this time? Other discussion topics relating to the certification of firms, or some call them provider organizations? And then, oh, so I'm seeing a hand raised by someone that I don't recognize as a member of the working group. Angela, can you clarify whose hand is up?
It's actually somebody from the attendee pool. Not sure why it's showing up, but it's from the attendee pool, not in the working group.
All right, and my understanding is we're not, by protocol, we don't entertain comments from members of the public during the working group meeting, but members of the public are welcome to submit written comments or to submit comments at the beginning of the meeting. Judge Bashan, Erica, do I have that right, Angela?
Yes.
That's my understanding.
That's correct.
All right, thank you then. And we do hope to receive the comment from the person who had their hand raised up. Other discussion topics relating to certification of firms or organizations in general? All right, move on then to tiers or levels of certification. Mr. DeBoe, did you have something?
No, is my thing up?
No, but I think I heard sound coming from your phone. Can you maybe mute? We may be getting the feedback from you. I'm not sure, from your phone or mic. Thank you.
I'll turn it off.
Thanks. So general comments concerning tiers or levels of certification. Here is the general statutory provision. Unfortunately, I can't show the list of discussion topics with that on the same page. Well, maybe I can do a little bit of it. So we have at least the start of a list of topics relating to the tiers that are required by paragraph 2 of subdivision B. Any other thoughts on topics that should be up for discussion in this regard? Mr. Kelly.
Just that I understood the state bar itself was the source of this 3-tiered program. And so I'd love to know what the state bar, what they intended, why.
Thanks, Ms. Cruz.
There one, perhaps training as something that could evidence a higher level of commitment, but not reflect an assessment of quality. So under 1, just like there's 2.1s under 2, perhaps added training levels as one potential way to recognize a higher level of commitment, but not necessarily quality.
Oh. Like I said, it will be messy here, but I will try and clean it up later. Mr. Pilevsky.
I think that it's difficult that in terms of ethics, there's different things we may deliberate upon aside from ethical baselines, but I don't think there's half ethical or almost ethical or more ethical. I think that when it comes to the ethical rules, there really can't be levels of certification. You either are ethical or you're not. You're following the rules or you're not. There may be voluntary things that certain firms do over and above, like refuse to take mandatory cases or cases without consent, which don't necessarily implicate the baseline ethics, but I think I want to be real careful to not create different levels of ethics.
Right, thank you. Mr. Tuckman?
Yeah, I agree with that. And maybe one way to think about it is that the first tier of the certification process really is some baseline standard of ethics that applies, whether you're talking about arbitration, mediation, whether it's family law, whether it's commercial. It's possible that that's one of the tiers. It's just the base level expectation regarding ethical obligations, compliance with obligations.
You have a specific example in mind that you would like me to capture here, just so when we come back, we have a clearer idea?
Sure. Well, and I mean, the one, if you're talking about arbitration or mediation, you know, the codes that come to mind for me, just because we use them the most, is the ABA, AAA Code of Ethics for Arbitrators and Commercial Disputes, right? So that's one baseline that could apply across, it's titled for commercial disputes. We'd have to think about whether all of the canons apply across different dispute types. There might be some variation, but you could create a generic code, I think, that would largely apply across arbitrators, for example. Mediation, I don't know how people feel about that, but model standards of conduct for mediators is a version of an ethical code that has gained some acceptability over the years. So you could use that again as some sort of baseline.
So I may have misunderstood. I thought initially you had said one level, but in a baseline related to all processes, but from the examples you're giving, I'm understanding that you're thinking of different baseline requirements, for example, arbitration than for mediation. Is that right?
That is true, although I was giving examples of some versions of ethical guidelines that might be a starting point. I think, you know, as I'm saying this, I think it's going to be a challenge. You know, maybe there isn't just one baseline code of ethics. Maybe there are two, but you could probably narrow it down to some smaller number. I think the idea, though, is again, one tier, one possibility is that the baseline tier is an obligation with some widely accepted ethical standards and obligations for ADR professionals.
So you're thinking there might be some common denominator, if you will,
Exactly.
between the different processes that could be extracted from the ethical obligations for arbitrators and for mediators. So maybe it would be something just generally like impartiality that might cut across multiple processes. Is that
right? Disclosure. Again, as I'm saying this, you know, there's many things intertwined. There's statutory obligations and the rest, but that is right. Some common denominator might be a starting point for the first tier.
Thank you. Ms. Kopekin.
Thank you. Yes, so first of all, I don't disagree with the concept, and I think it's worth us talking about whether there's a baseline, but I think it's absolutely essential that we differentiate between different forms of ADR to consider the policies behind arbitration. And for example, the ethical obligations have to do with disclosures, and the disclosures are much more extensive for arbitrators than they are for mediators, for good reason, because they're qualitatively different processes. So I think that it would be very important to keep that in mind. For example, the court programs, if the mediators who volunteer in the court programs were required to comply with the disclosure standards that apply to arbitration under the California law, it would probably gut the court programs because people wouldn't be willing to do that on a voluntary basis. And there isn't the same reason for having the extensive disclosures because, of course, a mediator has no authority to make any sort of decisions or determinations. Now, they do still have ethical obligations to disclose. It's just not quite as extensive. But I think that's a very important distinction that needs to be kept if we're talking about base guidelines. In terms of there being, there was a reference made to the model standards of contact, and I just want to say that I don't think that that is a baseline that is widely accepted. I'm not aware of any jurisdiction having adopted those. I may be mistaken, but last I checked, they had not been, for mediators, had not been adopted by anybody. So I just would not want to put that out there, certainly as an obligation on any of the people who volunteer in my panel. I know that would be problematic. So I'll stop there.
Mr. DeBow.
Well, I have a question. How do you establish whether a neutral is sticking to the so-called baseline? It merely says, oh, I'm going to adhere to the ethics. That's not going to work too well. You're going to have some way of establishing that they're doing something. And I'm trying to think, well, what's the way? Well, maybe they could, like an MCLE, they have 1 hour of ethics per year to take, but then it has to do it every year. You're not gonna, because if I take 1 hour of ethics in 2025, if I'm still around in 2030, that'll be kind of passé maybe. So that's my question. How do you establish whether this person is really has a baseline?
Thank you. And I'm hoping that you can all see what I'm typing. So if you feel I'm not capturing what you're saying, please let me know and I'll try and correct or clarify it. Thanks. Mr. Tuckman? Mr. Tuckman, your hand is up.
That was from before. I didn't know.
Okay, thank you. Thanks. Ms. Becken, are you again or from before? Yes.
I'm again. So on my point, it wasn't just court mediators, it was differentiating between mediation and arbitration as a, conceptually at all. But certainly I think the court mediation programs, as are largely volunteer, or many of which are largely volunteer, is a separate category that perhaps would require some exceptions or, special consideration. So I'll let you capture that. And then I have another comment or question, I guess.
Did I clarify that?
Yes, thank you.
Sure.
The other question or comment I have is that under section 6173B1, the procedures, where it talks about it does say the program shall include but shall not be limited to establishing procedures. It goes on then only to identify arbitration and mediation in subsections A and B respectively, does not discuss early neutral evaluation or facilitation or conciliation. Perhaps that means there is no obligation for this group to establish any baselines. I don't know, but just noting that there is nothing, it's limited to those two forms of ADR in the 6173B1. Thank you.
Thank you. Mr. Pawlowski.
Just to circle back, I think that what Eric's point, baseline ethics is great. I don't think the current rules are adequate. So I don't think that those are the baseline rules, whatever we decide them to be, need to be across the board. I think the extra levels can be what you had in your caption there for accountability and consumer protection, which are not really ethical issues, but I don't think we can have different levels of ethics in any way. I also, obviously, we have to have separate ethical rules for binding processes and non-binding processes. Mediation and arbitration are completely different in the ethical rules, especially as it comes to repeat players in multiple cases and marketing. They're very different. So I think we have two completely different mindsets. And Paul's point was a good one. We can require written policies and have those policies on file with the bar regarding various aspects of compliance and complaint procedures to help start the process of figuring out who's actually compliant.
Ms. Curtis?
Yes, following on Cliff's point earlier, and I think others have stated this too, that it doesn't make sense to have different levels of commitment to ethics. You either are or you're not going to follow them. And I think we might create something, be creative, but I don't think it's meaningful. And to imply that there are different tiers, I think is very misleading and really counter to the purpose of the statute. So I would pose another question, whether we should consider requesting the legislature to amend it to delete this provision or to modify it to provide something meaningful that can guide in the development of these various rules. The other thing is that standards for mediators, at least our subgroup will be handling those, and the legislature's been pretty explicit about how to go about that. So I don't think there's any need to discuss those particular things within this tier system.
Mr. Yamchan?
Thank you. I would never have imagined that we might have to go back and have specific definitions for arbitration and mediation. I am totally in support of distinguishing binding and non-binding processes. There are some providers that offer something called binding mediation. So I think we have to be careful there. Also, it would be wonderful if we could go back to the legislature. I'm not optimistic we can, given the nature of the legislative process. Bismarck once said, anyone who loves law or sausages should watch neither being made. And that certainly is an appropriate thought when it comes to our very creation.
Mr. Weiner, I just want to let you know that it's 2:44.
Our time for this discussion has passed or is about to pass.
It passed.
It
But
passed.
this is wonderful input, great suggestions.
Yes, it is. And I think this may be a good place to stop for now, and we pick up at our next meeting with this topics list. Erica and Judge Bashan, does that suit you?
Unless somebody has something really pressing, I think it would be great to continue it at the next meeting.
Thank you.
Thank you. That was great.
Why don't we do that then? Thanks.
Okay. So next on our agenda is item 2.5. Those are the subgroup reports. I can't wait to hear what the subgroups came up with. But our first is a report and discussion of complaints and remedies from that subgroup. And Dr. Jack Getz will give us the report. And there are 30 minutes allotted to this. Dr. Getz.
Thank you, Judge Bashan, and good afternoon, everyone. So I had a great meeting. We had a great meeting with our subgroup, which consists of Eric Tuckman, Ron Kelly, Paul DeBow, Sarah Hodgson, although Sarah couldn't make the first meeting. And I'm sorry, I regret that happened, but I'm looking forward to her participation at future meetings, and Katie Jones. So we had a very healthy discussion. We held this on March 5th. We initially began with some preliminaries. Maybe all of you and your subgroups began as well. Just things about how the subgroup was going to work, what we're going to do for future meetings, et cetera, et cetera. And we were successful at the end in scheduling 2 future meetings already. So we've got 2 more meetings on calendar, which is great. Maybe I'll share my screen because Alan, you didn't get to this part, but we use as our launching point. Judge Prashant, is it okay if I share the screen?
Yes, it is.
All right. We used as our launching point exactly what we didn't get to yet, that we were just about to get to. So we don't have the benefit of the full working group in doing this, but there were a number of discussion topics that the initial topics agenda developed for us. And so we just use that as a launching point to start talking about things that are in our category. And of course, our future meetings will probably be, have some additional topics that may be suggested by the working group, but these were the initial ones. We just haven't gotten to that part of the document. And we got to, some brief discussion of almost everything. We hit on it just topically, but a lot's left for the future. I mean, we don't have anything teed up for the working group to talk about at this point, except we did get a lot of robust discussion around are different grievance procedures necessary or appropriate for different types of ADR practice. So we were benefited in that discussion by Alan Weiner, who had drafted for us what I would call what he called a genericized complaint procedure document that hypothetically could be applied to all types of disputes or complaints that come up under whatever we develop the procedures to be. That could come out of an ADR procedure. And then I think after some discussion, and I'm going to invite our subgroup members to participate in this in just a minute, we came to a conceptual consensus that it would be possible to draft one procedure, one group of procedures that would apply to all different types of ADR. Now, there were a lot of caveats to that, and it's not yet, that procedure is not yet teed up for the working group. The caveats would be that, again, I'll invite my subgroup members to comment in a second because they could get into more depth on this. There would have to be specific protections for mediation confidentiality. There would have to be in arbitration specific protections that the complaint didn't seek to overturn an arbitration result. And then for other different types of ADR practices, I mean, Katie, you had mentioned a couple. I invite you, obviously you can participate after I'm done with this report if you'd like to. There may be other protections that have to be written into this one genericized policy. But the idea behind having one policy cover others was, one, for someone actually being able to apply the policy. It would be easier, particularly a lot of us handle different types within our own practice and within a firm's practice. We handle different types of ADR processes. So it'd be nice to have one genericized policy and procedure document that we could go to and become expert at, to the extent we need to be expert at that. And then And then, but again, the outstanding question was, could we in fact make sure that we provide the appropriate protection for the individual types of ADR processes? And that's what we're working on right now. And I guess without going into depth, I'd prefer to have some of the working members, our working group members who were members of that subgroup, comment on that conceptual consensus that we arrived at. Any of our members like to?
Paul has his hand up, Jack.
Oh, Paul, thank you.
Well, okay, I've had a problem with this because the statute doesn't help us very much. The statute requires an ADR practitioner to have a complaint procedure. The statute does not empower us to establish that procedure. It just says that the ADR neutral has to have a procedure. Well, if we stop there, though, it's useless. I mean, I can say I have a procedure. What is that procedure? How does it play out? So even though the statute is silent with respect to us starting a procedure, there has to be some kind of procedure in place so that the neutral who says he or she has a way to file complaints, there's a way to have that complaint consummated one way or the other. And one of the suggestions was that a neutral employ, in essence, 3 people to do this, and have a person who would receive the complaint, a person who would investigate the complaint, and a person who would decide whether the complaint was valid or not valid. Well, most those neutrals who are independent practitioners can't hire. They don't have people on their staff, so they can't do that. And even if they did, if I were to go out and hire 3 people and I'm paying that person, that alone, by the way, raises the bar to entry. Aside from that, if I'm paying that person, is that person going to find that that the complaint was valid and therefore lose his or her job and because I might fire that person for getting me into trouble? So there's all these issues are out there, and I've been thinking about this. And Alan had asked us to write him a letter. I have one that I wanted to do. I haven't done it yet, unfortunately, but I will, Alan, get it to you before the next meeting. And the thought I had, and I haven't expressed this prior to today, is to do something like the State Bar Mandatory Fee Arbitration Program. It's going to cost the State Bar some money, but have volunteers who would look at these complaints, and maybe the same people who are on the fee panel could do it. I don't know, and they would look at the complaints and make a decision. Because I don't think we have to have a procedure of some kind, and I don't think you can ask individual practitioners to have employees who are going to do it. Maybe the providers could have employees, because one complaint's not going to destroy a provider's business, or it may destroy an individual practitioner's business. So those are the things that I've been thinking about and I'm concerned about.
Thank you, Paul. And again, for the entire working group, we did touch on some of this, and I appreciate, Paul, you making the suggestion. You also had some other ideas during the subgroup. We are not ready to tee up yet. We were really looking to the next meeting to sort of work through the very issue that Paul's talking about, is what can we do about this? Can an individual really, or even a firm, be in charge of investigating itself, or at least reviewing a complaint? We've just begun the tip of the iceberg on this one, but I appreciate Paul bringing it up, and you you segued nicely into our next meeting. So thank you so much. Ron, I see your hands up as well.
Well, Paul leads into this question with his, and by the way, I think Dr. Getz did a good summary of where we did get. It was a lot of work to say, we think we can try and make one process for every kind of ADR provider. And I think that's what we're going to aim for. Something that Paul's comment gets to, and that there was a lot of discussion about, and I'd like some input from the whole working group, is, are we trying to make something that kind of tracks the language of the statute, which says a provider will have a complaint procedure, which to me implies that AAA, JAMS, Judicate could have their own internal process, or the community programs? Or are we going to try and develop something where there is a completely separate organization or organizations like MC3, like others, that take it out of the hands of large provider organizations, and that solo providers, for instance, can designate, okay, we'll make MC3, or the local court program if they'll take it, or something else? Are we trying to design a separate outside organization that will handle this stuff, or several of them? Or are we saying that major provider organizations, for instance, can have internal procedures? And I'd love to hear Mr. Tuckman comment about what's it been like for the AAA, for instance, that's been around for a century, that has handled complaints internally. Would AAA want the ability to continue doing so? And if so, could the public have confidence in an organization handling its own complaints? I'd love input from the whole group, but particularly from Mr. Tuckman.
Ron, before we get to that, thank you so much for that. Since Eric and you are both members of the subgroup, I was hoping we could get to a fuller discussion of that in our subgroup meeting before taking up working group time on that issue. Would you be willing to defer that discussion, you and Eric? And because I don't think we have time today within this working group meeting to really highlight all the issues that may be there under that. Could we defer that to the subgroup meeting and then bring it back to the working group for their comments once we've had that chance?
I defer to your leadership, Dr. Getz, but I would love to hear individual input through staff on that question to inform the subgroup's work. I don't think it makes sense for us to waste a lot of time if the working group says, no, we don't think that's a good idea at all.
Okay. So thank you so much. I mean, both you and Paul are bringing up all the great issues. I really appreciate it. And probably when we have more time in the working group, let's make sure we make a focus of our next subgroup, this very issue, and then we'll have something to bring back to the working group. But I would like to take subgroup time first so we can look at all that. Is that okay with you as well, Eric?
Sure.
All right. Thank you so much. Anybody else from the working group that would like to comment?
I see Mr. Polewski's hand.
I'm not on the group, but just two things. First, thank you all in that group. I think you got a real difficult task ahead. And this may be one of the areas, following up on what Dana said, where it may make sense to go back to the legislature. Because realistically, self-regulation isn't going to work, or at least inspire confidence. And if you start to go outside, then you're dealing with due process and remedies, and it's really way beyond anything, I think. So bless you all for trying. The one thing I wanted to ask the subgroup to consider, that aside from complaints about violations of ethical standards per se, and I know Eric and Kim probably have a lot more experience with this, I've got examples of large corporations writing and threatening the providers that this happened, this interpretation was made, these rules were applied, and we're so upset that we're going to pull all of our cases. Those kinds of business threats pose a real unique problem. And I don't know if there's a way to make them public or to require disclosure of those kinds of threats. It's one thing to make a private complaint, but threats against the business, I really think need to be disclosed to the parties.
Thank you so much. Well, rely upon staff, I think, to figure out which subgroup that goes through. It may go through our subgroup, but it may touch on some others as well. Well, Judge Bashan, I think that concludes our report. Would you like us to consider a motion on the conceptual understanding that we have, understanding that we don't have the actual policy yet? It's still a work in progress.
Absolutely. So let me just say it sounds like your group has consensus on having one set of policies and procedures that apply to all different types of ADR. Is that correct?
Correct.
Okay. All right. So there's a consensus from this working group, the Complaints and Remedies subgroup. I'd like to hear if there's agreement amongst all of the working group members. And if not, we'll take a vote. But is there any disagreement with that concept? Hearing none. That's excellent.
Among the working group, you're saying?
Yes, among the working group, this big group.
Oh,
Is there any disagreement with that concept? This whole group altogether?
I think it's
I see a hand, Mr. Yamshan. Oh, you're on mute. I'm sorry.
I don't disagree with the concept, but I'm wondering how one policy can cover the entire spectrum from community mediation to large complex cases. If it went to a vote, I would abstain because I would like to find out more, that's all.
Of course. And as Dr. Getz indicated, and I'll let him speak, I won't speak for him, but he indicated that there are many issues that they have to work out within this concept, and it's going to go back to them for that. And I think your suggestion is good and something that they will consider. But it's just the big overall overarching. Is there any disagreement?
I don't see how you could possibly have one grievance rule or complaint rule across the board. But I'll let the group take a shot at it. I'm happy to let them labor at it.
Okay. All right. Well, Dr. Getz, it looks like we have a consensus and there's no need for a vote. So excellent work by the subcommittee. All right, so we'll move on to the next subgroup report. We're going to do these a little differently, and it's just that we'll take the reports from the mediator subgroup and the arbitrators subgroup. We'll take them as they come, and we'll have discussion after the reports have completed. So now we'll go on to item 2.4, which is the report of the baseline certification for mediators subgroup. And that will be with Dana Curtis.
Thank you, Judge Pishon. And thank you, my great subgroup, for being so thoughtful and thorough and really working hard to get a lot done in a little bit of time. So I'm grateful to you, and Alan, thanks for helping us get it all set up and taking such good notes that could follow, especially for me since I'm giving this report. So the subgroup on mediator baseline qualifications, there are 6 of us on the committee and 5 of us were present. Nolan Armstrong was not able to attend, but I was there along with Claudia Coulter, Jill Kopickian, Maddie Robertson, and Chris Welch. And I will say that we bring a very broad spectrum of backgrounds and practice, so that was especially helpful to have a very well-considered discussion. So we met on March 11th. We focused on these qualifications. We all prepared by looking at the 2 documents that all of you received in preparation for today. That is the AI-generated document of topics And examples of qualifications are what we were calling topics, and also the state bar's document that we've just been going through, the media, and only it was the mediator section. So we looked at those two things, and between the two of them, there were 24 qualifications that we looked at. So before I get into what we did, I'd like to tell you a bit about our process. So the first thing we did is look to the working group charge to review what the interests were, or the objectives were that we were really wanting to achieve. And one is to ensure consumer protection, and the other was to balance maintaining rigorous professional standards with creating an inclusive program that accommodates a wide variety of practitioners. The next thing we did was to take a very high level, topic level poll as to each of these to see which are, I'm going to back up a minute. I will say that before we engaged in the examination of the various topics and working on the substance, we also considered Phil Diamond's issue that was raised earlier, and that I don't need to repeat. But we did decide nevertheless to go forward, and I assume that we'll have that conversation at another time. I think it's on the list somewhere. Anyway, so we just took a high level poll of which ones people thought should be included in qualifications, which ones should be excluded. And we came up with a number that we had consensus on that ought to be included, a number that would be excluded by consensus, and then sort of the middle ground. So we, as to the ones that we agreed about, well, let me just say, the next thing we did is we looked at the ones where there was not consensus, and we had a discussion so that we could understand what the concerns were, what people's perspectives were, and their analysis about the way they met or did not meet the interests. So we had further discussion as to each of those for which there was no consensus, but there were some votes in favor. And then we retook the poll and to see if there was any change. And then we moved on to look at the topics that we decided to exclude. We had a discussion of those, again, took the poll to see if there were any changes. And so what I wanted to do is to just read to you the lists and then see if you have any questions. And for all of the subgroup members, you know, in our group, please feel free to elaborate or add whatever it is that you think would be important for the working group to know at this point. So actually, before I start, the idea is that our next meeting, and we're going to have two meetings between this meeting and the April meeting of the working group. But in those meetings, we will first look at the sort of finish, you know, discussing some of that middle ground that I mentioned, but we'll go fairly quickly to developing specific recommendations. And that's where the real work begins. I think we've alluded to that in the other previous report. And so that will be, then we'll be prepared to come to you with specifics under each of the topics that we have tentatively agreed should be included. So I'll get started. Is there anything that you might add in terms of our process, subgroup members? No? All right. So we reached consensus. Well, the other thing I wanted to say is that we had a discussion about in the context of all of the discussions at the specifics, that we were not aiming for a performance-based set of qualifications. Thinking because it would be very subjective, and it also might run counter to the interest in having a broad variety of practitioners. So one would be training and development. We had consensus about that, as well as experience qualifications, that it would include a point system or alternative paths to being qualified, so as to allow for a variety of different practitioners to be included. Application, there would be a need to be verification, attestation to any documentation that was submitted in favor of the application. There would be complaint procedures and remedies, and renewal and recertification requirements. So those are the 6 that from the list that we had that we agreed would be included in our recommendation. We excluded the following: age, mentorship and assessment, legal licensure and experience, hearing and decision-making skills or temperament, language skills, availability, marketing or business plan, technology competence, and absence of complaints. And that's one we're going to discuss further, even though it's on this list. General education, the ones that had, had a middle ground, I'm going to let you know what those are, and then also the number of people that were in favor of including them. So general education, there were 2 people that favored that requirement. Other professional experience, non-legal, 2 people. Specialized knowledge, subject matter expertise, 3 people. Insurance or indemnity, 3 people. Moral character, criminal convictions, etc., 3 people. And references, recommendations, reputation, 2 people. Professional affiliations, 1 person, and certification levels, 1 person. So, so that's it. A subgroup, fellow subgroup members, do you have anything to add to what I've just reported? Okay. And I will say, not now, but I just want to give you heads up that we are looking, oh, sorry, Chris.
Oh, no, thank you. I mean, it was a robust conversation the entire time. And I think that we were very much looking at our baseline of what a baseline mediator is in our community versus the volunteer or the professional. And I think there was some dialogue about where that baseline truly was. And so I just wanted to mention that piece a little bit.
Yeah, good. Thank you. And thank you so much for all you contributed to that conversation, by the way. Appreciate it. And others too. So anyway, we would like for the working group at least to give us a sense and concept whether we're on the right track, and whether it makes sense for us to go begin the work that we would need to do to considerable work that would need to do to develop specific qualification requirements for the areas that I named, and dig a little deeper with the ones where we did not have unanimity. But that'll be after our discussion after the next report. Thank you. Oh, there's a question. Let's see.
So we were going to wait to take the questions and comments until after the report of the arbitrators subgroup. But Ms. Curtis, thank you so much. That was a great report. And it sounds like you and your committee worked really well together, made some great decisions.
Yeah, it was great. Thank you. And we look forward to when, Nolan, you can join us in the future. Thank you.
Thank you very much. And now we'll go on to item 2.5, and that is the report of the baseline certification for arbitrators subgroup. And that is presented by Mr. Weiner.
Thank you, Judge Bashan. I'm making this report on behalf of Judge Lucky for 2 reasons. Judge Lucky is the leader of this subgroup, but he was unfortunately unable to participate in the subgroup meeting on March 10th because he was stuck in and delayed by cyclones in an Australian trip. And he did have another engagement for today, but will be briefed on the input that the working group provides on this report. So the arbitration baseline subgroup consists of, as I mentioned, Judge Lucky as the subgroup leader, Ms. Ellis, Ms. Cruz, Ms. Lowe, Mr. Palevsky, and Mr. Yumshan. And all of the members were present for that working group meeting. And prior to that meeting, they were provided with the topics list section from what we've been reviewing today and what we had reviewed at our last working group meeting, just the section related to arbitrators. And they were also provided with what we're calling the AI generated or AI assisted list of criteria that various organizations have for including arbitrators and mediators on their panels of neutrals. The group actually, though, began by discussing whether the state bar has the authority to adopt qualification requirements in addition to the three that are specifically set forth in the statute, those being adherence to the Judicial Council ethics standards for arbitrators, having a complaint procedure, and having a remedies procedure. The working group had significant questions, let me say, about whether, I'm sure the subgroup had significant questions about whether that was something was in the working group's purview, or whether that would exceed what the statute provided for the state bar to do. There was a question raised about that as a result of the including but not limited to preface to those three requirements. And ultimately, the subgroup decided, reached consensus that there should be no requirements in addition to the three articulated in the statute, partially because of the questions about whether the state bar has the authority to adopt additional requirements, and partially because there were concerns that additional requirements could potentially serve as a barrier to entry, if making it more difficult for somebody who was new to the arbitration field to become certified. I'm just going to kind of touch on a couple of other views that were expressed and discussed in more detail at the working group meeting. And one was that perhaps there should be additional ethical obligations beyond those that are stated in the Judicial Council standards, specifically related to additional disclosures and also limitations on solicitation. And the working group did agree to take up that conversation, have a deeper discussion about whether there should be additional limitations on disclosure, limitations on solicitation, and additional disclosures. So I think those were, I guess there was also a question or a suggestion raised about whether there might be certain types of expertise that should be addressed in the qualification standards. I think coming from the recognition that sometimes traditionally parties choose an arbitrator because they have expertise in a given area. Just looking at my notes here, I think those were the main points or main discussion points, and the two items of consensus on which the working group agreed, basically, not to have qualifications beyond those specified in the statute, and to have further discussion about additional disclosures and limitations on solicitation of participants in an ongoing mediation. The working group has scheduled 2 additional meetings between now and the next the subgroup has 2 meetings scheduled on March 24th and on April 7th, both of which will precede the next full working group meeting. And I would invite other members of the subgroup to supplement what I've said. And I see Mr. Polewski's hand raised.
I just wanted to clarify that we are going to consider, I hope we are going to consider additional ethical rules that need to be complied with certification. Because I was confused by the consensus to not go beyond the statute, and then the second part, which I completely agree with, to consider whether the rules are adequate or whether they need to be supplemented.
Thanks for clarifying that. Dr. Getz, you're not on the subgroup, so I'm going to defer for just a moment and ask whether there are any members of the subgroup that want to supplement or correct anything that I've said. And then I think that Judge Bashan is probably going to facilitate the discussion among members of the working group on both the mediator report and the arbitrator report. So anything else from members of the arbitration baseline subgroup? All right, well, thank you. And thank you for your participation in the subgroup meeting. Judge Bashan.
Thank you very much, Mr. Weiner. Wonderful presentation, as are all the rest. It sounds like your group really participated and came up with some great ideas and really were thoughtful in the consensus that they reached. So for right now, we're going to take a break. It'll be a 10-minute break, and so 10 minutes plus 2. So we'll be back in session at 3:35. Okay, we're going to take a break now.
And as a reminder, please make sure you're muted, and you can go off camera if you'd like. Thank you.
Or ask questions. Okay, I'll start again. We're now ready to discuss the presentations made by the leaders of the arbitration subgroup and the mediator subgroup. And both groups came to a consensus. And before we start our discussion and questions, I'm going to ask Ms. Curtis and Mr. Weiner if you'll just state the consensus reached by those 2 groups, and then we'll start with the questions and comments. Ms. Curtis?
Oh, sure. All right, so we reached consensus that the following qualifications would be included on our recommendation: training and development, experience, a point system or alternative qualification paths, application, documentation, and verification, complaint procedures and remedies, renewal and recertification requirements. We will discuss further the following and we'll develop more specific proposals for you to consider next time, or recommendations. We will also revisit those qualifications for which there was not consensus, but there was some approval: general education, other professional experience, non-legal, specialized knowledge, subject matter expertise, insurance or indemnity, moral character, criminal convictions, etc., references, recommendations, reputation, professional affiliations, certification levels. And finally, we reached consensus that we would not include the following: age, mentorship and assessment, legal licensure and experience, hearing and decision-making skills or temperament, language skills, availability, marketing or business plan, technology competence, and absence of complaints.
Thank you. And Mr. Weiner, on behalf of the arbitrators subgroup.
Yes, thank you. The arbitrator subgroup reached consensus that there should not be additional requirements for certification of arbitrators beyond those that are specifically stated in the statute, which are adherence to the Judicial Council standards of conduct for arbitrators, having a complaint process and having a remedies process. The working group also reached subgroup also reached consensus to discuss whether there should be, excuse me, additional ethical requirements to those that are stated in the Judicial Council rules.
Thank you. Now I'll open it up to the entire group to ask questions and make comments. Oh, wow, lots of hands. Okay, we'll start with Ms. Hodgson.
I wanted to thank the subcommittees for their reports. I thought they were very informative and helpful. One of the things that I wanted to share from my personal experience as the ADR director with the court is considering how the different qualifications accommodate or account for different lived experiences and life experiences, particularly to encourage a diverse group of people to consider certification and being eligible for certification, and primarily to make sure that people find certified neutrals that reflect kind of where they're at in life, their lived experiences, their backgrounds, their demographics. So I wanted to encourage the subcommittees to kind of consider that as they continue to work through.
Okay.
Thank you. Mr. Kelly?
I'd like to echo Ms. Hodgson's comments and respectfully ask the working group to consider sticking with what the dozens and dozens of court programs have adopted as their requirements, which is, as I understand it, a 40-hour continuous mediation training and somewhere between 5 and 15 cases where they can prove that they've already mediated and have some experience.
Thank you. Ms. Cruz?
I had a few questions and comments for the mediation subgroup. So one of them is I didn't hear that one of the baseline requirements would be compliance with the mediator ethical standards, and perhaps I missed that.
Well, we're considering that separately, but absolutely.
I think that is a requirement for the baseline, and should be included because of that. And then the other big point that I just wanted to make for that working group's consideration is this. With respect to the baseline, it seems like, and this is what I think you heard in sort of the summary of our arbitration subgroup, you have to have at least compliance with ethical standards and a process, right, for complaints. Anything above that is not required, but could be included. And I worry that including a lot of extra things on the baseline is going to narrow your scope for your second and third tier for mediation. I also am worried that anything that evaluates quality runs afoul of the statute's express statement that that is not something that should be considered. And the points on, for example, experience, and then you had mentioned a point system as being another consensus. And so perhaps this is what Ron is talking about in terms of like maybe you've got to have 5 mediations or 10 mediations, or maybe it's something different. But either way, it smells a lot like quality to me. And I worry with experience, for example, considering that you've got 2 issues. One is that it could be very subjective, and the other is that it could be very arbitrary. So for example, if you go with, you got to have 5 cases, for example, why is the person who only has 4 not going to make it and the person who has 1 more is? So that's the arbitrary piece. And the subjective, if you take out those numbers or those points, then you risk somebody saying, well, Diana doesn't look like she has enough experience, based on whatever subjective criteria I'm going to use. And to Sarah's point, you're almost assuredly going to hurt people who come from exactly the areas that we want to encourage being, part of our mediation community. So just some thoughts for that subgroup. And I know on the arbitration side, we reached the conclusion that and the consensus that we really wanted to just stick with the statute and what it specifically told us to. You could go beyond that, but I do think it entails a lot of potential negative consequences that would be unintended. Thank you.
Thank you. Dr. Getz?
You're on mute.
I wanted to echo I'm sorry about that. I wanted to echo everybody else's comments regarding the fine work both subgroups did, and I really appreciate the comments. I regret a little bit that I didn't have a chance to input to the arbitration subgroup a little bit of maybe knowledge that I have from working with the legislative staff on the statute in my capacity as president of MC3. I think one aspect is the statute does say on qualifications when it refers to the ethical guidelines, it does say at a minimum. And when we tried to tweak that a little bit with the legislative staff and started to give them suggested mediator qualifications, their only comment was, they sound good, but we're not the right group. The state bar needs to flesh that out. And hence, that's why at a minimum came out in the statute. It's my belief that's why that language is there. So I'm not sure that the statute intended there to be no qualifications for arbitrators above just the ethical lines, number one. So I'm not convinced of that. Number two, it does strike me as unusual that any of us would have someone arbitrate a dispute without a basic arbitrator training course or some judicial background or something. And I invite Mr. Tuckman and others to comment on it, but I'm sure for their panels, they have some minimum requirements on training that might be necessary to serve in their group. So I'm just, I guess, respectfully asking the arbitration subgroup to reconsider, maybe, and I'm not asking for a lot, but I think it would be wise to have some standards. I mean, there is a difference between certification and licensing. And I don't mean to make this a debate, but licensing sets the minimum standards, but certification usually bears the moniker of the brand that it's representing. So it would be unusual, I think, for the state bar to certify somebody that they couldn't represent to the public, had any training whatsoever. I mean, I just think that would be hard for the state bar to do. But again, those are just my comments. And again, just asking if there was any chance you might want to reconsider that.
Thank you. And Ms. Robertson.
Thank you. So I think this sort of also goes back to our public comments and Ron mentioning, Mr. Kelly, as a threshold question of like, what are our goals here as a working group? Because it's very enlightening for me to hear this report out that the arbitration group had this consensus. I think it's really important that our subgroups are in alignment on the goals, because we should have alignment on whatever our recommendations are. It would be very awkward if our mediators have this long list and the arbitrators don't. They should really be mirroring each other to a large extent, not exact, of course, but so if we're setting our goals similarly, then that can be our baseline to work from to help keep ourselves in alignment. So I think we as a larger group need to have some agreement on how we're going about these things so that we're not completely disparate in our groups and meetings in between.
Thank you. Ms. Cruz.
I just wanted to second Maddie's comment. I think it would be really weird if the arbitration baseline was here and the mediator baseline was there. And I think we need to work jointly to at least get to here. My concern remains that if we started our baseline too high, and this goes back to some of our jokes about the ethics, we're going to be super ethical and, are you then going to be super experienced on the next level? And I think we might cut off our space to move upwards if we don't start low enough.
Mm-hmm. Any other questions or comments? All right, well, this is the time, as Ms. Cruz has said. We do not need to proceed in different directions with our subgroups. And I'd like to know if we can reach consensus based on what we've heard today, whether there is criteria which will be in addition to what's listed in the statute, or we will be limited to what's in the statute. Yes, Ms. Curtis?
All right, well, so I mentioned earlier that we wanted to have a sense about what the working group as a whole thought about our going forward and looking at in more detail at these 6 requirements that we, qualifications that we thought we would include. And those are, again, training and development, experience, some alternative path or qualification path to qualification. So, there's different ways to get there. Application and documentation verification, complaint procedure and remedies. And I would add, based on Diana's point, the adherence to ethical standards and renewal and recertification requirements. So, how does that sound as a sort of starting point to discuss? Well, maybe we can, I have a suggestion. Is there anyone present? And and I'll wait because you have some other points to make, but I'm suggesting that maybe we look at these 6 things and see if there's any consensus on any of them. And then we could talk about how to coordinate that to Diana's point of, making sure that we are inclusive and it's not performance-based or subjective, and the points that were made earlier. So that's my idea.
Okay, thank you, Ms. Curtis. But I just want to remind everybody, we need to see if we can get to a consensus regarding having criteria in addition to what's in the statute. And then we can move on to any specifics as to what they may be. Mr. Yamshin. Oh, I'm sorry, you're on mute.
Thank you. Kind of echoing both Diana and Dana, I think, well, first let me recognize the work of all the working subgroups, because obviously people are very committed to this. But I think given the differences and Dana's willingness to kind of move, but she has a working group behind her that helped her reach consensus. This may need some kind of negotiation, and I'm not sure that the plenary working group today, it could be in the future, but I'm not sure the plenary working group today is the place to negotiate that, because Dana, I would imagine, would want to go back to her working group and get a new consensus. And if the arbitration group thinks, well, okay, maybe we should move a little farther, then that working group might want to reach consensus on the changes as well. So I'm not saying that there's a great split. It certainly isn't like national politics today. But I think I sense a little bit more complexity than being able to just reach a consensus at this particular point.
Okay, thank you. Mr. Tuckman?
Thank you. Maybe this is again a clarification from Dana Curtis or her group, but training and development were on the list of requirements or issues that would be considered, but education was in the maybe categories, if I heard it correctly. No.
No, education was in the yes category. We didn't define that. I think that's where the negotiation comes in. But just as a topic to explore and to come up with a recommendation for.
Okay. Yeah, earlier I thought I had heard that training and development was considered to be something that was important. And then, there were a couple of other issues that were out that the group didn't think would be included. I thought I had heard that education and specialized knowledge were maybe still under consideration, but you're saying that's not the case.
No, education is in, special training and so forth is in the middle ground.
Okay. By middle ground, do you mean, sorry, I just want to make sure. Middle ground.
There were some of our members who believed that it should be a qualification for specific, we hadn't defined them, but in some specific areas, there should be specialized requirements, and others who didn't. So that's, there was no consensus. But there was interest in some, on part of some.
Okay, thank you.
Okay, thank you. Mr. Palevsky?
Yeah, as a member of the arbitration group, I am not committed to not having any standards, essentially. I got some bigger conceptual problems which make this whole thing so much more difficult. I really love ADR and believe in part in autonomy. And the beauty of both ADR, arbitration and mediation in concept, is that the parties can design a process, select the rules, select the arbitrator, and themselves protect fairness. So in the name of autonomy, I don't know that I feel we need a ton of extra rules. But in the arbitration world, none of that works without consent. So there is a need for more protection in the mandatory setting. The California Dispute Resolution Council, their very first principle is that if it's not a truly consensual process, it shouldn't be binding. So we're in this predicament of having to write rules for voluntary processes, mandatory processes, consumer protection, party autonomy. So I do think it deserves a lot more consideration. Just some overriding things that we should all take back to our subgroups is that there's a difference between legality and neutrality, and what is legal and what is ethical. And I think that's an important distinction because I think in many ways the courts have let us down in ensuring neutrality and ethics. And the other thing, which I don't think we're going to be able to address very well, but accessibility is very meaning to everyone here. As a practitioner, I can tell you that the costs of arbitration and mediation have gotten out of control. In the old days, ADR was provided in a nonprofit context and by people who were trying to bring peace and justice to the labor world. But now, we're talking $18,000 a day and $15,000 a day. And I'm not about to set limits on what people can charge, but it really is a shame that the fees, and I don't know if there's any way to certify that or require disclosures, but I wish there was something we could do to make it actually more accessible to people.
Thank you. Mr. Armstrong?
Yes, thanks. And Dana, I apologize for not being able to make our subcommittee meeting, and thanks for all the comments and hard work. One question that I had in terms of mediator qualifications or certification, however it's going to be characterized, is are we focusing as a group on trying to set standards moving forward for mediators looking to enter the field, or is it is the focus to sort of alter or change the standards for those already practicing? Because I think the latter is a harder task to achieve, and one that I think as a group we need to be more careful about. You've got people that have been doing this for 20 or 30 years, and if you're talking about enacting sweeping changes on their licensing or qualifications, that's it's potentially, I don't know, might not necessarily be a difficult sell, and it might not be something that we need to sell on them, but it might not be particularly well received within the profession. I think that's something we need to think about. Usually, trying to improve things going forward is, from a legislative standpoint, usually an easier task to achieve. So just food for thought in terms of if we want to create, exceptions or carve-outs for those already in the practice, and potentially make standards, give them more time to comply, whatever that might look like. But recognizing that there's a lot of people in the profession who work very hard and are only going to have so much bandwidth to comply with whatever we decide to enact.
Thank you. Mr. Kelly?
Piggybacking, I think, on what Mr. Polewski was saying, the high end of this, I hear people get 40 grand a day for mediating. And when arbitration and mediation was more things that people did with neighbors, volunteers, people who believed in peacemaking, there was a lot more accessibility. It was a lot cheaper. And if you combine that interest with the interest in making sure we don't have barriers to entry from people who want to get into the field and interests in diversity, I think it argues very strongly towards the way the arbitration subgroup came out, which is to stick with the three qualifications that were specified by the legislature, which were compliance with an ethical procedure that was specified, at least for mediators and arbitrators, having a remedy procedure, and having a complaint procedure. And I'll just leave it at that.
Thank you. Are there any more comments or questions? We do have time, so I don't want to move too quickly on this. If anybody would like to be heard. Yes, Ms. Cruz.
Am I the only one I want to go last if there are other people?
Mr. Yamshon's hand is up, so if you want to wait for him. And you're on mute. Mr. Yamshon, you're on mute. Mr. Yamshon, you're on mute.
Thank you.
Okay.
Yeah, Nolan, I think your thoughts were very well taken. As one of the 30+ year veterans, I remember what it was like to get started. And I've mentored people who want to become neutrals these days. And I think that if we make distinctions in terms of qualifications that could set up barriers to entry, especially since diversity is one of our goals, I think that I don't want to say it creates an equal protection conflict, but that's kind of the concept that comes to my mind without being able to think things thoroughly through. So I think we have to be very, very careful. Yeah, we have to create tiers, but at the same time, the last thing we want to do is create barriers to entry, I think. So thank you.
Thank you. I don't see any other hands, Ms. Cruz.
I have.
Oh, Ms. Curtis is still there.
And I'll go ahead of you, Diana, because you want to go last. I can say, here's the problem that I have with not having any qualifications other than agreeing to follow ethical standards. And I'm really curious about how you all got here, and because I think it could inform all of us. But and the other couple of things that you had to do. I don't understand quite how that achieves the interest in, you know, really looking at the, you know, sort of enhancing consumer confidence in the process, because, you know, we could find ways, I think, and need to find ways that people can assure compliance. There could be, you know, I have ideas. It's not appropriate right now. So I get that you could do that, and you could even make it stronger that to ensure that people would follow them. But if there's no other expectation except that they sign something that says they're going to follow them, then I wonder if we need anything, because like, I mean, it could be stronger legislation. They could say, if you want to mediate in this state, you have to sign on and, you know, in blood and say you're going to follow these. And we have they'll establish a complaint procedure. But, and maybe that's all they want, but I think it doesn't really say much to the consumer who's unsophisticated about, well, what have these people done? Or what have they, you know, what good is certification if it's not just a promise not to violate ethics?
Okay, thank you. Ms. Cruz? I think you're last.
Yeah, I mean, Dana, the point you just made is one that I struggled with quite a bit when I first read the statute, and the huge problem from my point of view is the sentences about this having nothing to do with quality, right? We are not your average consumer, average bear, but if we try to put ourselves in that person's position, you see the seal behind Diana's head and you assume it is a statement about quality, right? That Diana is more qualified than the other person who doesn't have the magic seal next to her name. And I do think that that's something that our working group should really carefully guard against. Because the statute says it's not about quality, I take it to be about ethics and disclosure requirements myself, but that's just me. I think that every single barrier we erect and every single requirement we erect at each level of certification is going to have an adverse impact on new people. And that's something that I want to guard against. I also think that when I got involved in this, one of my big concerns and something I heard from a lot of people was we don't want this to be a money grab, right? This is not, shouldn't be a pay to play system. And yet every single extra requirement we put on people is going to involve money. For example, if you require people to do a fulsome application, somebody's got to read that. Somebody's got to approve it. And of course, it takes time and money for the person to write it up in the first place. And all that money is going to be passed on to the consumer ultimately, which I think is something none of us want, frankly. I love your suggestion of kind of going back to the legislator a little bit, because I think we're in quite a catch-22, especially as we get higher up in the tiers. Because what are we going to do beyond like the minimum and still not run afoul of the don't make this about quality piece? I think training's one potential way to thread the needle, but other than training, I'm very personally scared of things like experience, education, right? I know people who are completely uneducated that are some of the best mediators in the world. And I think that we're going to have problems running through a lot of the areas if we make them requirements on people ultimately. This to me really just underscores Diamond's point in his public comment. And, you know, the John Derrick article on this, I think we have to be really careful about getting too far from what the statute says. That's just my own take on it. But I recognize, Dana, your point exactly, right? Then where do we go?
Just to clarify, we didn't say that education should be a requirement. It was training. Sorry.
Okay, thank you. Ms. Coulter.
Thank you. As a subcommittee member of the mediation subcommittee, I just wanted to clarify, part of my thinking was, and a lot of the conversation was really around our community mediators and limiting the restrictions on entry. So I'm one of the ones who felt like education was important, but not a master's degree. a high school diploma or a GED or something equivalent, some really basic baseline. And if that's not something that the committee agrees with, then that's not something the committee agrees with. But the intent of this subcommittee was to really think about everyone who could possibly be involved in mediation. So I just wanted to like point that out, that the conversations were not about creating barriers to entry. It was really about limiting those barriers and making them as bare minimum as possible, but still expecting that people are having some sort of training. Thank you.
Thank you. Anyone else? I appreciate how respectful we are of each other's opinions. That's wonderful. That's a great sign of professionalism. I do want to point out what the statute, some of the words of the statute that most of you have alluded to, and that is the program shall include, but shall not be limited to all of the following. And shall is a mandate, shall not be limited to. So yes, Ms. Ellis.
Thanks so much, Judge. And I am glad you, are redirecting us to the statute. I think this was discussed at length as part of the arbitration subgroup, and the area that we wanted to explore in relation to shall not be limited to is a little bit later. And if you guys have the topics list page open, I have it as my page 6, but I have the language there. In addition to identifying the ethics standards, we know that different levels or tiers must meet all of the following requirements. This is B2. And then B, the levels or tiers do not reflect an assessment of the quality of a firm, provider, or practitioner. And so this is the portion of the statute that we were really grappling with in our subgroup. Thank you.
I'm sorry, which subgroup was that?
The arbitration.
Okay.
Baseline, yeah.
Okay, thank you.
And I think, Alan, if you scroll up just a little bit.
There it is. Oh, you're passing it in. Perfect.
Oh, Mr. Dubois.
Well, we may be going far afield here. Why was this statute passed? It started with that article in the Los Angeles Times where these 3 retired judges who were erroneously characterized as mediators apparently were not controlled by anybody and just willy-nilly allowed Mr. Girardi to take money from settlement funds. And there was no way of stopping them. There was no control over them and no way to complain about them. So I guess what the author wanted was a procedure by which members of the public could file complaints against or about ADR professionals, and those complaints would be resolved one way or another. And secondly, to have some assurance that there has been that the ADR professional with whom they deal or dealt with has experience of some nature. In other words, I can't just go out and graduate from high school and put a shingle up saying Paul Dubois, ADR neutral. I can't do that. So that's what we have to do. So first of all, I think I would simplify everything. We need to have some way to assure the public that we have some background in the field in which we're acting. And that may be training and maybe something else, but it has to be something. And secondly, we have to have some kind of complaint procedure or a way by which a member of the public could complain about us. I recognize if we did that, we're gonna get a lot of complaints that are erroneous. They're just people who are dissatisfied by the outcome and not really impacted by a bad conduct by the professional, but they now think he or she was wrong because they ruled against them. So that's my position.
Thank you. All right, let's see. I don't see any more hands. Okay, I don't see any more hands. So the subgroups are going to go back and do their work after this meeting. They need to know what the entire group wants them and what direction we would like for them to proceed. I haven't heard consensus from the group, although I've heard that training is very important and that is a criteria. So since I haven't heard consensus, I'm going to have to do that other thing, which we don't like to do, and that's we have to vote. So because the subgroups need to know the direction we want them to go in so that we don't end up at the end with two different recommendations to the legislature. So the question is, should we consider requirements beyond the statute? Yes, Erica?
Sorry, just a procedural question here. So I think there's two options for the working group. This could be a straw poll to get clearer consensus, or someone could move the question that Judge Pichon has presented.
Thank you. Yes, Mr. Pulaski.
Is it possible to let us go back to the arbitration group and among ourselves first discuss the issue of qualifications? Because there may not be such a big divide here, and it may be hard to just put together a particular thing to vote on without identifying what it is we're talking about. I'm certainly open to some minimal qualifications as a concept to reconcile the two. I don't know that I feel comfortable voting on it as
And which group are you with?
the arbitration.
Oh, well, the question is not what the criteria is that should there be any that's beyond what the words of the statute?
Well, you said training, whether there should
No,
be a
I
training
said,
requirement. You did
I'm
say-
sorry. No, I heard many people who are opposed to going outside of the statute mention training. And so that indicated to me that there could be agreement regarding requirements beyond the statute. Mr. Dubois.
Well, my inclination is to abstain from your question. And the reason why is it's too broad. I mean, what's the limit to how far we can go? And, and that bothers me. So I'm not sure I want, I understand where you're coming from, Judge. And obviously we have to do something beyond the statute. But I'm a little nervous about saying, can we just go beyond the statute?
That's what the subgroups are for.
Okay, well, all right, but that's just my view.
Okay, all right. Mr. Yamshun?
Yeah, the subgroups may be for that, and with all due respect, the subgroups may not get into alignment. So we're at this juncture. I think Mr. Polanski's idea is terrific that this may be a bit premature that the arbitration subgroup, since we have 2 meetings before the next plenary meeting, we can discuss it, see if we're able to reach a consensus within the subgroup as to where and what the additional requirements may be. And then we have to think, as Diana pointed out earlier, how is all this going to fit into the tiers? It's not so simple that we can have a plenary meeting, a subgroup meeting, and be ready to come up with any final ideas by the second plenary meeting. It seems to me, I could be wrong, the group is far more intelligent than I, but I think the idea that the arbitration subgroup should have the opportunity to work through this is a very good one.
Okay, thank you.
You're welcome.
Mr. Kelly.
I really liked Ms. Doherty's notion of a straw poll here. If the vast majority of us think one way, that's good information for the subgroups. If the vast majority think the other way, that's good information also. So I'd like to make a motion that there be a non-binding vote taken about whether we should stick with the 3 criteria expressly expressed in the statute, which are adherence to an ethical set of standards, a complaint procedure, and a remedy procedure. That's my motion. As a straw poll, not a binding direction to the subgroups.
All right, all right.
We need a motion on a straw poll.
Does someone want to second that? Okay, so it's just to see where the positions are amongst our group. Okay.
And just to be clear, you don't need a second on a straw poll, so just for the
Okay,
for the
thanks.
record, so
Thank you.
Angela can take the straw poll vote whenever you're ready, Chair.
Okay.
And just to be clear, this is just for the baseline, right? Just for the lowest level, not for the other 2 where we can go crazy with the extra. Well, I'm not suggesting we go crazy, but just for the baseline, should we be looking at more than these 3 things, or should we stick with what the statute says?
That is it. Thank you, Ms. Cruz. That's absolutely right. Okay, so the straw poll will be, should we consider requirements beyond the statute? Does that sound right? Okay, all right, Angela, would you please
Or the
take the straw?
baseline.
Oh, the baseline, okay. Angela, would you please, oh, I'm sorry, Dr. Getz, do you want to speak first?
Yeah, I just wanted to make sure I was clear in my earlier comments, because the statute says the words at a minimum. So I'm not sure the way the motion's framed that what we're voting on. And the question is, does at a minimum have any credence at all, have any place? In other words, is there meaning to that? Was it intended to imply that we should have other qualifications, which I believe our work with the legislative staff would indicate? So the statute could be read to be said, we only do the 3 things that you specified, but it could also be read to say that's just the minimum and we should be doing more.
Okay, thank you. Mr. Kelly.
My motion was, as a straw poll, should we stick with the 3 things that were expressly identified in the statute? Ethics, complaint procedure, and remedy procedure.
Okay,
Again, for the first tier, sorry, but right.
I'll consider that a friendly amendment to my straw poll.
So a yes means you want just those 3 things, and a no means you want 4, 5, 6, 7, 8 also to be potentially on the table for the baseline. And now I think we're ready to vote.
Would you like me to take
The only question I have is tiers. Tiers, we're not.
What are 2?
Did you want to include tiers in that?
No, because I think all of us
good,
understand
good,
you have to
good.
go beyond the baseline in the,
Okay.
right, which is actually part of the point of where are you going to go if you start this high?
Okay, all right, so should we stick with these 3 things as stated by Mr. Kelly? All right. Angela, would you please take the straw vote?
Yes. Armstrong,
Yes.
Coulter,
No.
Curtis,
No.
Dinkin,
Yes.
Dubois. Mr. Dubois, your mic's on mute.
Yes.
Thank you. Ellis,
Yes.
Dr. Getz,
Dr. Getz, we couldn't hear you.
No.
Higuchi,
Yes.
Hodgson,
No.
Jones,
Yes.
Kelly,
Yes.
Kopaken, Cruz,
Yes.
Lowe,
Yes.
Pulaski,
Yes.
Robertson,
Yes, Robertson, we couldn't hear you.
Yes.
Thank you.
Yes.
Tuckman,
Yes.
Welch,
No.
Yamshan,
Yes.
and Judge Pichon.
No.
What's the count?
The yeses have it.
Yeah, 13 yeses and 6 noes.
We need a good mediator.
All
I do
right,
think
then.
the straw poll is indicative of the like majority consensus if it was 13-6.
Thank you. Yes, Erica.
Recognizing that we have just a few minutes for this, I do think it'd be helpful to ask the subgroups to some extent where they go from here, recognizing that this was a straw poll, in the sense that the mediators, from what I've heard, the mediator subgroup was going to be going through a lot of possible qualifications for baseline. So I think it would be helpful for them to know if they should turn to, if we are past baseline now at this point, frankly. If so, I might suggest it's not a straw poll. And if we should pivot the existing subgroups to move to tiers or otherwise. Just recognizing that the subgroups already have meetings set. These existing subgroups have meetings set in between now and the April full working group meeting. And Alan probably has something to direct us in a better path than what I've just articulated.
Well, no, I would just add to it that I think it would be helpful. There have been concerns raised about what the parameters of the tiers would be. Folks, I think, including Ms. Cruz, have said, you know, that that the limitation by not including quality kind of restricts what the tiers can require. So I think it might also be helpful to have maybe not a poll, but a discussion about what folks think the tiers could look like that would be on top of the baseline requirements and within the limitations of the statute.
Ms. Curtis?
Yeah, I'm confused about the use of the term tier. And I think it would, for me, it would be more helpful to know, are we talking about a particular qualification? And then it would become, you know, how do we find some common ground that would achieve, you know, what we all hope to achieve? And I mean, I don't really think it's a straw poll and we say, okay, we're not going there, it's all done, without looking at what some of the options are and seeing if there can't be a way to take a second look.
What I heard was that some members of the arbitrators subgroup asked to discuss it further.
Oh,
and wanted to know what the direction, how the members felt. And Ms. Cruz, if you think I've misstated that, please correct me.
No, I think that's exactly right. And I do think, Dana, that the mediators group should reconvene and talk about that too. And listen, in an ideal world, we'd actually be on the same page at the baseline, right? And so I don't think it could hurt. And Judge Pichon, I guess this is a question for you. If maybe we could have some crossover between our chair and Dana or someone like that, so that maybe we can all just work together and potentially get on the same page. I don't want to create more work for anybody, but I do think we got a lot of great minds here. We should be able to figure this out, and hopefully in a consistent fashion.
Thank you. Ms. Robertson?
Thanks. I too am struggling with this like plain language versus legislative intent idea. So I just pulling up the law right now and it says higher tiers are awarded to firms, providers, practitioners that demonstrate a higher level of commitment to accountability and consumer protection. And I think that is kind of where we're gonna have to keep coming back to, but I agree it is this sort of like academic question of intent versus plain language.
Thank
But
you.
just to remind us of what it says.
Okay, thank you. So we have 2 minutes before our guest speaker, Mr. DeBow.
Well, I'm gonna go far out here, but I really am very bothered by the whole idea of tiers. And I might suggest we could consider going back as a part of our report to ask the legislature to amend that to have 1 tier. And here's why I don't like tiers. I think they create a barrier to entry because the people will be more inclined to use a ADR professional who has a higher tier rating than one who has a lower one in most cases. And maybe they can't, maybe the only reason they won't do that is affordability, because I guess the higher tier people will charge more money because they have a higher tier. And I'm bothered by that tremendously. And our job would be so much easier if we had 1 tier. Thank you.
Thank you. All right, so we've heard what members of the working group, how they feel and what they are thinking. And now it will be necessary for the subgroups to get back together. And there was the question about whether the leaders of the subgroups could get together. I don't have the answer. I'll ask Ms. Doherty for that.
Yeah, unfortunately not, because you would be cross-communicating with each group is 6, so that's 12, which would be the majority of the committee. But what I think we could do is, you know, after this meeting, discuss the agendas for the upcoming working group meetings with the chairs and determine if this is, you know, these are long meetings. It's 4:30. I'm sure you are all feeling the afternoon fatigue and these very substantive conversations this afternoon, but perhaps some of the time, if necessary, could be taken for this robust discussion amongst the 21 of you.
I think that's a great suggestion. And with that, we'll go ahead and move to our guest speaker. Our guest speaker is Merrill Hirsch of Hirsch ADR PLLC and the law firm of Merrill Hirsch PLLC in Washington, D.C. Merrill Hirsch is an arbitrator, hearing examiner, mediator, and the executive director of the Academy of Court-Appointed Neutrals, as well as chair of the ABA Judicial Division Lawyers Conference Court. I didn't say that right. I'll try it again. ABA Judicial Division Lawyers Conference Court-Appointed Neutrals Committee. He has litigated cases on behalf of both plaintiffs and defendants, as well as the United States government in federal or state courts for over 40 years and in over 40 states. With that, I introduce Merrill Hirsch. And thank you so much for being here.
I'll just ask, I believe Merrill is currently in the attendee pool, I believe. So I've reached him, I've just sent a chat, but if you could raise your hand, assuming it is you, if you could raise your hand out of the attendee pool and we'll promote you. Okay, I'm not seeing anyone raise their hand. I'm not sure, Alan, if it's possible he's not here yet. Is that correct?
Yes, that is possible. He had indicated that he has another meeting that was ending at 4:30. He thought it might take him 5 minutes to get here. He thought he might get here at 4:35. And I don't know, I believe that Angela sent him a link that should bring him in with presenter status. Is that correct, Angela?
Yes. Okay, thank you for clarifying.
So Judge Pashon, I think you have a few moments if you like. I apologize that we weren't able to schedule Mr. Hirsch to get here exactly at the end of the other agenda items.
I was simply trying to keep him from having to wait, but so that's that's fine. So I enjoy this group very much, and it is an honor to be chair. And I love the discussions that we had this afternoon, and I know that we will keep it up. And I hope that you'll keep up your hard and good work in your subgroups. I don't know when Merrill Hirsch will be here. We could potentially break for 5 minutes, or if there's anything you'd like to talk about for the good of the order, we can certainly do that.
Break.
Break? Okay. Yes, all right. Why don't we take a 5-minute break, and that will take us to 4:38. Okay?
Thank you.
You're welcome.
Greetings. Just correcting one small thing. Okay. All right. Let me pull up the slides if I can. Can you all see these slides?
Yes.
Okay. So let me see if I can. There we go. Okay. So what I'm going to do is talk about court-appointed neutrals. I have two goals in this. It's all for your information to make any use of. One is to understand what they are so that you can make a judgment call about whether they're covered by the statute you're trying to implement. And the other is to discuss what the status is of analysis of the profession and professional standards, so that you can get some background on that. I have to do a disclaimer. It's purely for information. I'm not attempting to lobby, and these are my own views. So what is a court-appointed neutral? Basically, that's what we're talking about. A court-appointed neutral is a Swiss Army knife. And it can be used in a variety of ways by courts across the country, particularly as part of the most modern thinking. They can be used to help avoid disputes in the first place. A court can appoint somebody and say, help the parties work out this discovery mess so it doesn't end up being motions on my desk. It can help resolve disputes, either by working with them after they're filed or to make initial determinations of motions. It can help provide expertise. Basically, any expert in any field that might be of use to a court, that's what a court-appointed neutral can be. So you have a case that needs, a forensic accountant to figure out where money went from a trust, or someone to help the parties work through business valuation, or a nuclear physicist for that matter. It can be any type of expertise that the court can draw on. Help provide information. You could ask a neutral to go investigate facts and report back to the court. Help convey and insulate. Sometimes, for example, the parties may be discussing settlement. They don't want the court to know about settlement, but they'd like a message that deciding this motion might be a good idea. Or it could be judge who's going to have a bench trial doesn't want to look at the privileged documents on the privilege log, prefer to have somebody else review them and report to the court on the standards being applied rather than revealing it. Help ensure fairness. Critical part, as everyone knows, of justice is for people to feel heard. Courts can't engage in ex parte contacts with the parties, generally speaking, and they can't, through resources, talk personally with every claimant who's involved in a large case, for example. How do these people feel heard? How do they feel part of the process? You can have neutrals used that way. Help move dockets in a variety of ways, come up with creative ideas to assist. There is a definition of the profession. This comes from a model rule that I'll speak about a little bit, but the ABA adopted 3 resolutions concerning court-appointed neutrals. One, in January 2019, adopted guidelines, which I'll get to. Two, in 2023, one of them called for a change of the name from master or special master, which is why I'm using court-appointed neutrals, as both a much better term to be using and a much better description of the job regardless. And the other adopted a model state, local, tribal, and territorial rule in court-appointed neutrals. This definition comes from that rule. And as you can see, it's intended to be broad. It's intended to provide courts with a lot of discretion on what they should do and how they go about doing it. However, while the definition is broad, there's also a carve out because the rule concerning court-appointed neutrals isn't intended to supplant, for example, court-based ADR programs or create separate rules. So if a court already has a rule system setting up a court-based mediation program, for example, that stays as it is. It's not affected by the rule. So that's how the definition is constructed. By the way, I'm happy to take questions, if they come up. California has a number of provisions of the Constitution, CCP, and rules concerning court-appointed neutrals. Basically speaking, they're pretty broad. It depends on the circumstance and whatever, but if you go, there's a lot of discretion in courts to decide how to use neutrals in various settings. So I won't take you through the details. You can look at the slides or better look at the statute, the CCP and the Constitution itself. But by and large, courts have a lot of discretion to make use of this Swiss Army knife that we're talking about to appoint a neutral in a case. So the role that the neutral serves, and part of what makes it very complicated to set up like principles of ethics that apply to court-appointed neutrals, is it isn't just one role. It could be quasi-adjudicative. Neutral, got these discovery motions, do something about them, or do a report and recommendation from a hearing or on a motion for summary judgment that I'll consider, or any number of things. Could be facilitative and not adjudicative at all. Help the parties work this out. You're not going to be making any adjudicative decisions here. You're going to be using ADR skills to help facilitate the movement of justice. Could be informative or using expertise, as I mentioned before. Could be investigative. Could be an intermediary, as I mentioned before. Could help implement. You can appoint a neutral to help monitor a decree or help work through claims that come up in after a settlement or after a class-wide judgment or group judgment, handling individual claims or structuring a claims resolution process. It could be just broadening and supportive. You're bringing in people with different types of expertise, and even more so, wearing a different role, having a different role. They're not wearing a robe. And so there are limits of what courts can do by reason of their position. Sometimes, for example, it's awkward for a judge to say, well, how about this? Because the next day they may get a motion saying, as Your Honor told us, you should do A, B, or C. Whereas it's easier to have somebody, attempt to facilitate it or work with the parties along with it. It basically broadens the court's power to do things by using different types of techniques. Has a very long history. As I'm sure you know, that's William the Conqueror. The belief is that the idea of using a neutral in one of these ways came to Anglo-American law with the Norman invasion. If that's the case, the use of court-appointed neutrals in England predates the use of English. And it was in the first case in the Supreme Court. The Supreme Court has held over 100 years ago that there's inherent power to appoint court-appointed neutrals. The thing is that while it has a very long history, really hasn't been talked about very much. And in some ways, it's almost a very long, well-established role that nobody's ever thought much about to establish it into a coherent profession. And so in some ways, court-appointed neutrals are way behind mediation and arbitration in thinking about how you want to do the ethics or other rules. Some of these developments came from the ABA. In 2012, the ABA established a committee with a ridiculous long name and that has no known acronym, but basically it was to look into how you could make more effective use of court-appointed neutrals. What the committee did is form a working group that across 10 of the sections, divisions, forums of the ABA, who worked for 18 months and came up with, as I mentioned before, consensus guidelines on the appointment and use of the first version of this said special masters, and it's since been amended to say court-appointed neutrals in federal and state civil litigation. The basic idea behind the guidelines is courts could make more effective use of this tool if they consider them as a regular part of administration. Not necessarily appointing in any case for sure, but that it shouldn't be something weird or strange. It's just a tool like any other tool. And if you regularize the consideration, there are a lot of benefits that flow from that. People will be more familiar with the tool so they can use it more effectively. You can vet people and set up rosters. You can involve stakeholders in the process of using them, so it isn't just a judge appearing to appoint their friend. You can train people, you can vet people, and you can improve the process. Then in August 2023, as I mentioned, the ABA adopted two other resolutions. One was on primarily the name change, and the other was this model state, local, territorial tribal rule. Now, the model rule is worth looking at because it contains aspects of discussions of ethics. It contains a lot of procedure designed to make this a better process. It is a long read. Okay, this took 3 years to draft. It is very detailed, and so it's not like, oh, I'll just plug in clause A, B, and C. But it does kind of take you soup to nuts through the process and maybe of some assistance. In the meantime, the Academy of Court-Appointed Neutrals, I started out with this ABA committee. They did an internal review and they decided, well, gosh, we should become part of what the ABA is doing. And they asked me to be their executive director to make the organization outwardly facing, help broaden the profession, help support the ABA in thinking about how we could make this more useful for courts. There is a document on the ABA website, the ACAN bench book, which always was a really good document, but we have more recently refined it. It is basically a compendium of information about what considerations you might think about in appointing a neutral, what are the different types of neutrals, how do you go about selecting a neutral in a way that's fair and casts a wide net to get a broad group of people instead of being repeat players, how you can draft there are examples of orders that set forth what the neutral is going to do and under what circumstances they're going to do it. There are discussion. The most thorough discussion of court-appointed neutral ethics is in that, and then there's a compendium of resources associated with it. And ACAN also posts a lot of resources on its website. There's a resource drop down, there are articles, there are these resolutions that I was talking about, and a variety of other things. ACAN also adopted guiding principles that its members agree to follow. And it's not a full-blown code of ethics, but it's rather a page saying, here's what our members are going to do. And that's potentially something you might want to look at as one of the, attempts to provide information on what the standards are for court-appointed neutrals. Then both ACAN and the ABA Judicial Division Lawyers Conference Court-Appointed Neutrals Committee have worked to develop principles of ethics. There is no general ethic guide to court-appointed neutrals. It's a difficult task because they serve many roles. So a simple question, can you have ex parte contact? Well, what is it you're doing? Are you mediating a dispute in the parties? Yes. Are you adjudicating a dispute? No. So there are so some of these are situational. There are other complexities because a court-appointed neutral is an officer of the court. And so in most states, in all states, an officer of the court has to comply with the Code of Judicial Conduct in some measure. In most states, the enforcement mechanism for that is the judge. Whatever oversight organization of judges doesn't usually do the enforcement of other court staff. So if, for example, a law clerk reveals confidential information, it's the judge's responsibility to act in connection with the law clerk. And It's complicated though, and nobody sat down to figure out what provisions of the Code of Judicial Conduct do and do not apply to neutrals. Clearly, some do, maintaining confidentiality. Clearly, others, like, you can't work as a lawyer at the same time. Most court-appointed neutrals do work as a lawyer, and you wouldn't want to say, well, I want to use this person to review a privilege log, but by the way, you have to give up your law practice in order to do this. So one of the issues is what pieces of this apply, and that's what we're thinking about, but no one's established. Clearly, if a court-appointed neutral is a lawyer, and not all of them are, but if a court-appointed neutral is a lawyer, the neutral is subject to the Code of Professional Responsibility in whatever state. The Code of Professional Responsibility only mentions that role a couple of times in passing. So what you have is, clearly it would be unethical as a lawyer if you took on a role as a court-appointed neutral and were incompetent to do it. But literally Rule 1.1 in the model rule, for example, says competence in representing a client. It doesn't literally apply to it, but in principle, it ought to apply. Of course, you can't take on something incompetently. That ends up more complicated in DC, where I live. For example, our Court of Appeals has held that lawyers holding involved in other types of fiduciary responsibilities have to comply with the sense of the model rules of professional responsibility, model code of professional responsibility. In that context, even though literally it doesn't apply. So for example, if a lawyer is a trustee, they can be held to a standard of competence for trustees under Rule 1.1 in DC. I don't know that that's the law in every jurisdiction, but it is a law I'm familiar with. So part of what we're working on is to develop this into probably not a standalone code, but at least guidance. Perhaps the deliverable for this will be a book of essays discussing different issues. We've also developed a series of hypotheticals on ethical issues that kind of frame some of the issues with a discussion of how you might go about analyzing them. Those are also, we can make those available if those are used. We are planning the first ever symposium at New York Law School on September 24th and developing papers for that symposium specifically on court-appointed neutral ethics. Nobody has ever spent a day trying to discuss this subject before, so we're excited about it. All right, so where does that leave us? Development standards are in early stage, not been addressed before. There's no generally accepted code of ethics, no implemented standards for service as a neutral. There's no enforcement mechanism, but there are guiding principles that can be cited and references done in working on articulating specific. Now, this is the website for the Court-Appointed Neutrals Committee. It has a lot of the materials that were generated by the APA, plus articles, plus some video stuff and other things. And you can get it by Googling ABA and court-appointed neutrals. There are links to the resolution, videos, support mechanism. This is the website of the Academy of Court-Appointed Neutrals. You see both on the left of the screen bench book, and also at the top there's a drop-down menu with bench book. The drop-down menu also contains training modules that are based on the base bench book. You also see on the top resources. Those are all the places that I was referring to in discussing this. Or you can contact me. So, that's basically what I had to present, but I'm really happy to answer questions if it would help.
Are there any questions?
See Alex.
Yes, we see Alex.
Yeah, so Judge Pashana, I just, first of all, thank you, Mr. Hirsch, for making the presentation and for all the work you've done on the subject. Just for the working group to provide a little bit of context on why we invited Mr. Hirsch to speak with you, take his time and your time this afternoon, is because Business and Professions Code Section 6173 says, for purposes of this article, alternative dispute resolution means mediation, arbitration, conciliation, or other non-judicial procedure that involves a neutral party in the decision-making process. So I think most members of the working group are pretty familiar with either mediation or arbitration, but there's this world of other ADR processes that Mr. Hirsch has been talking about. And so we just wanted to kind of provide some background on that, and this will be a subject of much more discussion among the working group, but we thought this might provide some context.
Any questions? Well, thank you so much, Mr. Hirsch. It was very informative, and it's information we're going to use in our future discussions. Thank you for taking the time to be with us this afternoon.
Thank you, Judge. I really appreciate it. Okay. So with that, I guess I'll leave, if that's
yeah,
okay.
it's okay. Yes, yes,
Okay.
it's okay.
Thank
Thank you so much.
Bye.
Bye. So, members of the group, we've had a very productive meeting this afternoon, lots of discussion, very important discussion, and very meaningful discussion. Our next meeting is going to be on April 23 from 2 to 5. And unless there are any questions or comments now, I look forward to seeing you at that time, and roll up your sleeves for those subgroups, because you're doing a great job. Thank you.
Thank you.
Thank you again for your facilitation of this meeting.
Thank you.